Welcome to Environmental Law course, dear learner and viewer. In continuation to our discussion of the international and national dimensions of the biodiversity law, we have taken note of the catena of the conventions and recommendations and guidelines in relation to biodiversity governance at international level, including the Aichi targets and its implementation at the national level. On the other hand, we have also taken note of India's enactment of the Conservation of Biodiversity Act, Conservation of Biodiversity Rule, and Plant Variety Protection and Farmers' Rights Act, and as well as the Access and Benefit Sharing Guideline of 2014. With, with this, we see that the entire mechanism of the biological diversity law and administration in India is being governed by the law. What we can say that there is a three-tier mechanism, and that three-tier mechanism starts from the National Biodiversity Authority, and the National Biodiversity Authority is empowered to see that how the knowledge associated with the biological diversity are to be applied and to be implemented. In this reference, we see that the knowledge associated with the biological diversity and the biological resources and the knowledge associated with the biological resources, the Act has classified the biological resources as number one, the biosurvey, bioutilization, commercial utilization, and research. So these four categories, these broadly four categories: the biosurvey, the bioutilization, commercial utilization, and the research purposes. This is the knowledge associated with the biological resources. So the biosurvey and bioutilization invariably appears to be same, and that's why section 2B of the act includes the survey, collection, species, genes, component, and stack for purposes of such characterization, inventorization, and bioassay, and this encompasses the bioperspective. So this is something very fundamental when we are going to discuss about the biodiversity law and administration in India, to have a deeper understanding as to what biological resources mean and how the knowledge associated in relation to the biological diversity and biological resources are going to be harnessed and to be applied and inculcated and imbibed. Therefore, in this reference, the another important component appears to be section 2F, which talks about the commercial utilization, which include biological resources, commercial product like such as drugs, industrial enzyme, food flavors, fragrances, cosmetic, emulsifier, oleoserines, colors, extracts, and genes for crop and livestock improvement via genetic intervention. The Act tries to regulate all these activities to ensure conservation, sustainable use, and equitable benefit sharing from the biological resources, and thus we see that the biosurvey and the bioutilization reflect scientific and explanatory use. This is one aspect, that it has a scientific and explanatory use, while the commercial utilization targets for the trade and industry. This is the another use, and the third is the research, which is involved biological resources are to be regulated separately, and it has a separate kind of a demand and a separate kind of a conception which appears to be bona fide. So under the biosurvey, bioutilization, and commercial utilization and research utilization, we see that how the access to the biological resources or the biodiversity resources and associated knowledge are going to be implemented under the National Biodiversity Authority. So we see that all these four components are important, and thus we see that the National Biodiversity Authority, under the mandate of section 21, is created by the Ministry of Environment and Forest and Climate Change, and then we find that the National Biodiversity Authority has been defined under section 2J and section 8 of the Biodiversity Act. On the other hand, we find that at national level, there appears to be an expert committee of the National Biodiversity Authority along with the National Biodiversity Authority, and then we have a State Biodiversity Committee, which is being promulgated under Article 20, Section 22, and as it has been under National Biodiversity appears to be established under section 2J, defined and established, we see that this law has a three-tier mechanism, and the three-tier mechanism include that national, state and the local level, and thus we find that at district and village level, the Biodiversity Management Committee and Panchayat or municipality institution of self-government is defined under section 2H of the Act, and it confers power on the Biodiversity Management Committee. So, one hand we find that National Biodiversity Authority, on the other hand we find the State Biodiversity Authority, and then we find Biodiversity Management Committee as it has been envisaged into the Conservation of Biological Diversity Act 2001. Thus, we find that who are the person and how this law is going to be applied, then we have to find that who are the person. Then we have already taken note that either it is foreigner, either it is happens to be the NRI, it is happen to be the Indian citizen, and the categorization of this legal entity that pertains to, it can be a body corporate in India or the foreign entities. Similarly, on the same analogy, being the NRI and the foreigner and the citizen, it also include Indian entities and foreign element, Indian entities and foreign element in matters of the body corporate and association who are entitled to access the biological resources in India. The entitlement of the biological access to the biological resources conferred on these entities, then we find that the intellectual property dimensions of the biological diversity has been thrashed out under sections 4 to 7 of the Act, which addresses that the intellectual property aspect, including control over the research result, commercial use, and benefit sharing under the regulatory framework of the National Biodiversity Authority. Section 4 talks about the result of research not to be transferred to certain person without approval of the National Biodiversity Authority. Section 5 talks about the person not to apply certain collaborative research project. Section 6 talks about the application of intellectual property rights not to be made without prior approval of the Biodiversity Authority, National Biodiversity Authority. And section 7 says that the prior intimation to a state biodiversity board for accessing of the biological resources for certain purposes is being granted. Thus, we see that right from section 4 to 7 is the implementing mechanism, what has been said about the access to biological resources and the knowledge associated with the biological resources, and under the three-tier mechanism, these are the person who are entitled, and these are the provisions relating to the intellectual property dimension of the biodiversity resources, which has been engrafted from section 4 to 7. We also see that intellectual property dimension of biodiversity, the provision happens to be the who are the benefit claimer, which has been defined under section 2, who happens to have the research result transfer, which exclude publication or knowledge dissemination in seminar if done following central government guidelines is being guided by section 4, and all kind of collaborative research project between Indian government institution and the foreign entities are exempt from section 3 to 4, but it should conform to the guidelines as per the section 5 of the Act. Thus, as a whole, we see the application for intellectual property rights related to biological resources requires National Biodiversity Authority's approval, and after its acceptance, it should be granted within 30 days. And in this reference, when we talk of the rule 4 to 7, we also take note of rule 18 of the biodiversity rule framed under the Act, and especially the form 13.3 is very important, and we see that this is the form 13 which was enacted under the rule 18, and rule 18 was enacted to give effect to section 4. So when we talk of section 4, we should take note of rule 18, and we should also see form 13, which is very important. So, when we talk of 4 to 7, which talks about intellectual property dimension, the very idea makes it itself complete after taking recourse to rule 8 and form 13. So, we see that the form 13, how it talks about is try to give a kind of a questionnaire, and that all entries are to be filled with greater detail, and that gives the idea that how these biological resources are going to be used and to be patented. Under the patenting of the biological resources, as we have noted that it is one foreigner, non-resident Indian, foreign entities, Indian entities with foreign entities, collaborative project, and we see that here the conflict of the BD Biodiversity Act and patenting regime that has been sorted out in case of section 7. That section 7 is of a great help in this respect. What we find that these entities require NBA approval while using the biological resources or associated knowledge for commercial or research purposes or for biosurvey and bioutilization. So this is something very important what has been said under section 7, and then the prior intimation with which apply to the local community, and but for the person who are already having their local indigenous community, they does not apply to, they does not apply to have any kind of a prior information, because they are the cultivar, they are the breeders, they are the conserver, and that's why we see while adopting the patenting regime in the conservation of biological diversity law, we do not find that kind of stringency as it has been witnessed in the Patent Act or the TRIPS model of the IPR, but here we have some sense of community participation and the community approach, and that community approach is reflected here. So thus the patenting of the biological resources requires again the permission of the Central Biological Diversity Authority. In this case, we find that the case in point which deals with Research Foundation for Science and Technology and Ecology versus Union of India, the petition was filed by Dr. Vandana Shiva challenging the patenting of the wheat by Monsanto before the European Patent Office. The petitioner also sought direction of the Indian government to challenge the patent and set up a permanent body. That is very important. Setting up of the permanent body to correct record regarding the traditional Indian wheat variety NAFL. So, what was the concern of this organization? That it is the first case of the biopiracy, meaning thereby in the name of access to the biological resources, that it requires that we have a legal framework, but at the same time that the very care and caution which are to be applied in case of extraction of the traditional knowledge. And this is one of the point that the Indian variety of NAFL wheat which were patented in Europe. So Supreme Court, the petitioner's concern was that like this, there are many Indian best knowledge system on the biological resources and biodiversity concerns. That knowledge are gradually and dramatically transferred in the name of use of biological resources. So there is a need of a caution. So Supreme Court in this case has said that the petition to be infructuous, noting that the government was already taking a step to preserve the biodiversity. It means the government have taken that whatever is the bureaucratic setup under the NBA appears to be the whatever is the Supreme Court was of the view that whatever is the safeguard which has been granted to National Biodiversity Authority is appears to be satisfactory in the opinion of the Supreme Court, and then in the opinion of the Supreme Court, what we see that the step which they have taken appears to be satisfactory. However, this case resulted into a kind of a disappointment to look very carefully the cases of the biopiracy. In another case known as AKB Jagannath Nag versus Union of India, the Calcutta High Court in 2016, wherein the appellant sought intellectual property right approval under Section 6 with Section 19(2) of the Biological Diversity Act, the High Court observed that the subsequent approval under the Biological Diversity would affect earlier order passed by the controller of patent. Here, the incongruency and the incompatibility of the Patent Act and the Biodiversity Act appears to be very visible, and that's why the court clarified that if approval was already granted after impugned order, the appellant could seek the review and appeal under Section 117 of the Patent Act. So, the court under this act highlighted that there is a need to clarify the term biological material in the Patent Act, and it is this provision which is compounding confusion. And both the act, the whether Patent Act and the Biodiversity Act, must have a very analogous and holistic approach in defining what is biological material, so that the competing claims of application of the Patent Act and the Biodiversity Act can be resolved amicably. Thus, the legal policy as a whole, we see that the Biological Diversity Act defined biological resources, and it also have some kind of implication in triggering Patent Rule 2003, Draft Patent Amendment 2015, which introduced provision relating to handling application where permission from the National Biodiversity Authority is not obtained within the prescribed time, but the term appropriate order remains undefined. Thus, we see that whatever has been laid down under Section 19 of the Biological Diversity Rule, which requires prior approval of the NBA while applying for the intellectual property protection based on biological material knowledge obtained in India, is also refined by patenting regime. So there is something which is going to happen in the direction and the concern which has been expressed in AKB Jagannath Nag versus Union of India's case in 2016, to set the house in order and the need for the harmonization between the Patent Act and the Biological Diversity Act to ensure regulation of patenting of the biopiracy, the prevention of the biopiracy, and patenting of the biological diversity and biological resources are to be done in a very judicious manner. With this, we try to see that what are the role of the National Biodiversity Authority, because we are going to discuss the issue of the law and administration. And law and administration can only be discussed in reference to number one, the role of Biological Diversity Authority, and this chart says that what are going to be done by the National Biological Diversity Authority. Then we see that it try to have regulation of access and IPR. It also talks about conservation, it talks of documentation, it also talks about the benefit sharing. So under four major heading, we are going to track that how the law and administration in the arena of the biodiversity is going to happen. So what we see that the NBA's permission to seek foreign national before accessing biodiversity and traditional knowledge, and how the NBA advises the central government on matters of conservation of biodiversity, sustainable use, and protection of people's traditional knowledge, and how the documentation process is being started by the National Biodiversity Expert Committee, which is based on the documentation by mainly primarily by the BMC, the Biodiversity Management Committee, under the Chapter 4 of the Act. And on the issue of the benefit claimer and the benefit sharing, it tries to see that how equitable regime are going to happen. On the other hand, it talks about the Indian nationals are also to seek permission. So Indian nationals are not exempted. Here we can drop the case of the Divya Pharmacy case. In Divya Pharmacy case, Divya Pharmacy, being Indian national, wanted to seek approval, wanted to seek exemption, and saying that whatever provision has been contained, that the Indian company and Indian nationals are not supposed to file for any kind of the permission from the National Biodiversity Authority. So in Divya Pharmacy, it was said in all the cases, whether it is Indian or the foreign country, this law applies. What is the difference? The difference is about the payment. Somewhere it is 0.5%, somewhere it is 1.5, somewhere it is 2. So it is only in case of the payment it differs, but this law is equally applied. So on the aspect of the conservation, the NBA tried to guide the State Biodiversity Committee and the government. On the other hand, what we see that NBA, taking an overview which is based in Chennai in Tamil Nadu, is very multidimensional, facilitating conservation, ensuring sustainable use, as we have noted. It also tried to see and regulate the access of the biological diversity and intellectual property among the foreign and Indian national. It advises on the government, or it creates expert committee to act as a think tank NBA also enforced the fair and sustainable use. It also tried to grant approval relating to IPR. Thus, the very administrative structure of the biodiversity law and administration as it has been permeated into National Biodiversity Authority appears to be a kind of a nodal agency. In this reference, we see certain cases like Environment Support Group versus in National Biodiversity Authority, where the decision was of Karnataka High Court and as well as National Green Tribunal. The petition filed against the responsibility of biodiversity regulation over the alleged piracy of the brinjal. As we have seen the cases of the case of the wheat by the Vandana Shiva, that was the Indian variety of the wheat Nafal. Here we see the brinjal, and that variety which was contested by the Environment Support Group, Bangalore, regarding the brinjal germ to a non-Indian seed company without NBA approval. So that was the contesting point. The Karnataka High Court transferred the writ to National Green Tribunal, and then we find some kind of administrative crisis that whether the National Green Tribunal is also empowered to look at the cases of the biodiversity dispute. Then we can refer to section 52A of NGT 2010, as we have noted in the previous lecture, that empowers, and then the case happens to be resulted that in NB action a criminal complaint was filed in Dharwad regarding the biopiracy of the uh, biopiracy of the brinjal, biotechnological development of the brinjal, and we see that the first criminal prosecution under the biological diversity appeared in this country in Dharwad. So this case has great significance in not only trying to see the parallel and the concurrent role of the High Court and as well as the NGT. This case has a seminal significance in understanding the role of the NGT and the role of the High Court, whether High Court was right in transferring the writ petition or whether the NGT was right to hear directly. And this is what is said to be in India a process of tribunalization of environmental justice. So this case is important from the point of view of the competing claim of adjudication of the NGT and as well as the High Court, and in reference to the tribunalization of environmental justice. Vis-a-vis, this case is also an eye-opener to the fact that the first criminal prosecution under the Biological Diversity Act regarding the biopiracy was registered into a genetically modified crop known as brinjal germ plasm, and then we see that how some criminal proceedings were stayed for 6 months by the Karnataka High Court, Dharwad bench, and happens to be an unprecedented manner. Therefore, this judgment has been criticized severely on one count, that the High Court has not only stayed for 6 months the operation of the criminal proceeding against the defaulter. Number two, the High Court was also abdicated its power in favor of the NGT on both the count that looking to the core of the issue of the biopiracy of the brinjal germ plant by a non-seed company, a great opportunity was lost to have a clear and unmistakable order and stricture in this regard. Thus we see that the commercial use of the biological resources which has been given under section 5th and especially the section 19, 20 and 21 grants approval by gives power to the NBA to grant approval after certain inquiry and consultation with the expert, with minor questions and counter questions from the applicant. Then the case law on this point is something very important, that the chess scientist case in 2008 involved illegal collection of insect from Singhaliya National Park, and without permission of the NBA permission, and these two scientists charged under section 27 and 29 of the Wildlife Act and later under section 3 of the Biodiversity Act, and they were convicted by the Chief Judicial Magistrate Darjeeling and have imposed a fine of 20,000 rupees and sentenced for 3 years imprisonment. The case highlighted the issue of the biopiracy, which is not only going on the hand of the foreign companies, not going, not being undertaken by some of the commercial firm and the commercial use, but even for by the researcher and for bona fide research purposes. The scientists are also involved in cases of the biopiracy. What we have seen in the previous case of the brinjal germ plant was a company, a non-Indian seed company, or what we have noted in the previous case of the Research Foundation versus Union of India's case, it was dealing by the Monsanto, which is a a big company, a giant company. So, besides looking at the cases of the biopiracy under this law, we are also having the cases pertaining to the biopiracy from the scientist. And this case is very important and eye opener, and therefore, in this case, the Calcutta High Court have taken ultimately a very relaxed view, taking into consideration they are scientists and they are very educated people and have summarily uh, try to evict them and try to give some kind of a relief to the chess scientists. But looking at the gravity of the crime, which was booked under Section 27 and 29 of the Wildlife Protection Act, along with Section 3, we are now sure of the fact that Indian biodiversity, in the name of access of the biological resources, are also being invaded and is in danger in the hands of the scientists. Then we have another case from Kerala that talks about the Japanese national case in 2015, where the two Japanese national collecting reptiles from Athipalli forest without NBA permission, and they were prosecuted under both Wildlife Protection Act and Biodiversity Act, and that violation under 59 was also invoked. On the other hand, we see that in Western Ghat, biodiversity vulnerability was reaffirmed by the Planters Forum versus State of Kerala regarding ecological fragile land, and field level enforcement of the Biodiversity Act has been limited due to low awareness among the forest official and forest dweller. So this case have tried to reveal the fact that the very essence of this law is the equitable benefit sharing, and the communitarian approach is being missing at the local administration of the biodiversity law. Whereas the Japanese national case also reflect how the nationals and the scientists without NBA's permission were collecting reptiles and how they are going to be prosecuted. So, taken as a whole of the case law of the transfer of the biological resources, we require that it is to be examined at the patent level, it is to be examined at the application level, it is to be examined inside India and abroad, it is to be examined from the transfer of the research results also, and we should see that the transfer of the biological resources under section 20 and 21 requires the the approval of the NBA, and NBA should ensure that it result into equitable benefit sharing by the utilization of the biological resources on mutually agreed terms between the applicant and the local bodies. So, the access and benefit sharing methods are to be applied by section 20 and 21 should be applied in a letter and a spirit. Thus, the section 19, 20, 20, 21 taken as a whole, which try to give emphasis on the benefit sharing among the local community by the user of the biological resources, are to be applied in right earnest. On the issue of the transfer of biological resources, we also find that we have an ABS guideline for fair access and benefit sharing, and that has been promulgated in 2014 by the Ministry of Environment and Forest and Climate Change. So, whatever has been laid down by Section 19, 20, 21, and 22 is to be further carried out by the benefit sharing method and the transfer of technology under the ABS guideline of 2014, and thus the Rule 14 to 18 of the Biodiversity Rule 2004, which lays down the procedure and detailed procedure regarding the approval of such application for seeking intellectual property protection, needs to be examined under the Form 2nd and Form 4th in a very meticulous manner, and thus we see the entire national strategy of the biodiversity conservation law appears to be that from section 36 to 40, the Biological Diversity Act focuses on the development of the national strategies and conservation and sustainable use of the biological diversity. The principle which has been underlined under section 36 to 40, the one talks about the national strategy. At the international level, we have the Aichi targets, and a replica of the Aichi targets is being underpinned under section 36. 36A talks about the measures taken by the NBA. 36 talks about the measures to be developed by the state board and biodiversity heritage site, how it is to be managed, and how the power of the central government to notify the threatened species, designated species are to be promoted. With this national strategy, we see that the mandate of the National Biodiversity Authority and as well as the State Biodiversity Authority and Expert Committee under Section 8.4 Subclause D mandate for the appointment of non-official members who are expert in conservation, sustainable use, and benefit sharing. As a whole, we see that besides the National Biodiversity Authority, the State Biodiversity Authority, which has been established under Section 22, 23, 24, and 25, has also analogous and similar function in regard to commercial utilization and utilization of the bio survey and bioutilization and commercial utilization and utilization by the research purposes. And a perusal of section 9 to 17, which apply to a state biodiversity board, we see that is in alignment to the National Biodiversity Authority. On the other hand, we see that the documentation of the Biodiversity Management Committee is also carries greater importance simply because of the fact that there is a need for cultivar fork variety, and we try to see that how IPR related matter are to be documented. Here, what is important under section rule 22 of the constitution of the BMC is to see that there is a 1/3 mandatory representation of women and 18% reservation for scheduled caste and scheduled tribe, and thus it is a communitarian approach which has been adopted in biodiversity management committee to see that the conservation as well as the documentation should go with the consultation of the local people. And in this respect, we find that the Biodiversity Management Committee has a greater role at the local and grassroots level in conservation, in documentation, in access and benefit sharing, and overall administration of the biological diversity in India by promoting People's Biodiversity Register, and which try to document the flora and fauna which are restored comprehensively, record traditional ecological knowledge, identify biodiversity challenges, capture community conservation practices. It also revive the community conservation practices, It provides a critical tool for biodiversity planning by identifying the training needs of the BMC members, and it recognizes bioresources for access and benefit sharing agreement and propose geographical indication registration as well as develop conservation strategy and maintain access register and regulate resources. Thus, we see by giving and by understanding the respective role of the Biodiversity Management Committee in chronicling, in documentation of the traditional resources at the grassroots level in matters of regulation of access and IPR, conservation, documentation, by giving representation to local people, we see that the three-tier mechanism under the biodiversity conservation law in India is a very effective mechanism which was not witnessed in Environment Protection Act, which was not witnessed in Water Act, which was not witnessed in Air Act, as it has been seen in the case of biological diversity law and administration, which truly represent the federal aspirations and the aspirations of the traditional community, and it tries to see under its intellectual property approach to deeply encompass the repository of the traditional knowledge while having an administration in regard to access to biological resources in a sustainable manner and providing an access and benefit sharing among the community by a process of incentive and reward to see that biodiversity resources are being nurtured in a very amicable manner. With this, we end up our lecture of the biodiversity law and administration. I thank and I wish you a happy learning.